Hi, my name is Jake Howell, founder of JT Howell PC, an employment law firm serving all of California and based out of San Diego, California. Today, we're going to talk a little bit about the litigation life cycle. 30,000-foot view of what to expect from the time you decide to initiate a lawsuit till the time that lawsuit is resolved. Generally speaking, process takes anywhere from 6 months to 2 years. I've had cases that resolve quicker. I've had cases that take up to 5 years. However, most of them, 6 months to 2 years. Court has a stated goal of handling it in just 1 year, but that rarely ever happens in actuality. So, what's the first step of the process? First step of the process is a pre-litigation investigation. Pre-litigation investigation is when you come to me and you tell me what it is that happened to you. At that stage, we're going to start collecting evidence, right? We're going to start collecting emails, text messages. We're going to talk to people who have witnessed this, and we're going to find out exactly what causes of action we have and who we have those against, right? So we're going to decide basically who are we suing and what are we suing them for. Simple. Now we're going to file the complaint. That's when we file a document with the court telling the defendant, hey, this is who we're suing, and this is what we're suing you for. Plain and simple. They're going to answer. They're going to say, we didn't do any of that. That's expected. That's why we go to the next stage, written discovery. Written discovery, very simple. We ask them questions that they have to answer truthfully under oath. We also ask them for documents, right? We're going to collect their emails, their text messages. We're going to collect any physical evidence related to your claim. And once again, they're required to give that to us. Once we have this evidence, we're going to know exactly who we need to talk to and what we need to talk to them about. And that's where we move to the next phase, depositions. Depositions, fancy word, all it means is I get to ask them questions and they get to ask you questions about what it is that happened, and all the parties need to answer under oath. We find out a lot of really important information here, and they get a sense for what it's going to be like at trial when they have to answer for what they've done. During this process, sometimes we get more information and we find out, hey, we need to ask for these documents that we didn't ask for before, or we need to interview these people that we didn't interview before. So as you can see, it's not linear. It doesn't go from written discovery to depositions to expert witness to discovery motions. All of this stuff's kind of happening at once. But to keep it simple, written discovery, depositions, and then expert witnesses. Expert witnesses help us fill in the gaps. They let the jury know what should have happened, right? So they can testify to certain topics that they're experts in, that the court deems them experts in, and they can let the jury know what should have happened and what did happen. So what went wrong. There's an old saying, if you see a dragon, you're probably close to gold, right? You can think of discovery motions as the dragon, right? We are getting close to something. We're asking for important information that they don't want to give us, so they're going to try to block us. Right? And that's when we have to file discovery motions to force them to give us what we need, or they're gonna file discovery motions to stop us from getting what we need. Either way, this is when we go to the courts and we fight the battle to get you what you need, to get us the evidence that we need to prove what happened. Now, this next stage, motion for summary judgment, sometimes it happens, sometimes it doesn't. This is simple. This is one of the parties going to the judge and saying, hey, here are the undisputed facts. Here are the things we all agree upon. Based on the things we all agree upon, there is no case and it should be thrown out. Sometimes they do this with just a couple things that we're suing for. Sometimes they do this with the entire thing. Either way, this is expected. We fight it. We say to the judge, hey, these are the disputed facts. These are the things we don't agree upon. Based on the things we don't agree upon, we have a case, and we need to bring that case in front of a jury. Now, at this same time, while we're working on this motion, or after we defeat this motion, we go into what we call settlement talks or the mediation stage. This is where most cases resolve. Now, we can have settlement talks at any time. If at any time during this process, the other side decides, hey, we're going to be reasonable, we know we did wrong, and we want to give a fair amount of compensation to the plaintiff, to you, then great. We're ready to settle at any time for the right price. But we're also not going to settle for less than the case is worth. Oftentimes, they're not ready to settle until after all the discovery is done and they can see everything that happened, and until after they know that the judge isn't going to throw out the case. But if they're not being reasonable and they're not willing to pay us what we're owed, then we go to mediation. Mediation, simple. We get a neutral third party in and we give him the facts of the case and the evidence that's been uncovered, and we say, hey, look, this is what they owe us. They're not willing to pay it. They do the same thing, and we go there for a day, and the mediator goes back and forth, and he discusses with us the pros and the cons of the case. And he discusses with the other side the pros and the cons of the case. And we talk about where it is that a fair settlement can happen, what the case is actually worth, and what it is we should resolve the case for. Oftentimes, that's it. The case resolves here. The neutral third party is able to talk some sense into the other party. We come to a fair number, and we walk away from the lawsuit. However, if they're not willing to offer us the right amount, that's when we proceed to trial, and we get to present the case in front of a jury of our peers. Most of the time, juries get it right. And when they get it right, we get paid. However, sometimes juries get it right, and the defense just is not willing to accept that. When the defense isn't willing to accept it, they sometimes appeal it to a higher court. They say, hey, something happened at trial that wasn't okay. It doesn't matter, but they'll try to appeal it. They'll try not to pay you. That's okay. That's when we go to the higher court and we say the process was followed, everything happened correctly, and the verdict is both legal and fair. And yeah, that's the entirety of the litigation life cycle. If you have any more questions about the specifics of each stage in the litigation life cycle, I'm going to make a video on each of those. You can find those on the YouTube page. If you live in California and you think you have a case, text me or call me. Happy to talk about your case anytime. Happy to get you what you deserve. Thanks for watching. Bye.